Excelentísimas autoridades, excelentísimos señores
Excellent
académicos,
authorities,
señoras
excellent
y señores.
academicians, ladies
Abrimos
and
esta
gentlemen,
solemne sesión de
we
recepción
open this
del
solemn
excelentísimo
reception
señor doctor
session
Enrique
of the
Morera
Honorable
Guajardo como
Dr.
académico
Enrique Morera
correspondiente.
Guajardo as a corresponding
Ruego a la
academician.
excelentísima señora doctora
I
María Ángeles
beg
Calvo Torres,
Honorable
académica de
Mrs.
número y vicepresidenta de la
Dr.
Junta de
María Ángeles
Gobierno
Calvo
de
Torres,
esta
she's a member of the
institución,
Academy and Vice
proceda a la
President
lectura del
of the
acta de
Board
elección
to
del
read
nuevo
the
académico.
act of election of this
Con la
new
venia.
member.
María Ángeles Calvo Torres,
María
académica
Ángeles
de
Calvo
número y
Torres,
vicepresidenta de la Junta
I'm
de
member
Gobierno
of
de
the
la Real
board
Academia
and
Europea
Vice
de
President
Doctores,
of the
certifica
Governing Board of
que
the
en el
Royal
libro de
European
actas
Academy
de
of
esta Real
Doctors
Corporación,
say that in the
correspondiente a
minutes
las
of this
Juntas de
corporation
Gobierno, figura con fecha 12 de marzo
we
de
are
2019 el acuerdo
in the
válido, entre
March
otros,
31
de
of
nombrar
2019
académico correspondiente
women
al excelentísimo señor doctor Enrique Morera
say
Guajardo,
Dr.
y
Morera
para que así
Guajardo as a
conste,
member
a
of
los
the
efectos
board
de su toma de
as
posesión prevista para el
effects of
próximo día
possession
30 de noviembre de
for the
2022,
30
firma el
November of
presente en Barcelona a
2022
24 de noviembre de
signed the present
2022 con el
in
visto bueno del
2022
excelentísimo señor
having
presidente.
the excellence Mr. President
Ruego
signed.
de nuevo a la
I
excelentísima
beg
señora doctora
now
María
to
Ángeles Calvo Torres,
Mrs. Dr. María Ángeles
académica de
Calvo
número
Torra,
y vicepresidenta
member
de la
of the
Junta de
board and
Gobierno, tenga la
Vice
bondad
President
de
of the
acompañar
government,
a la
to
presencia de todos los
please
aquí
accompany the
reunidos
presence
al
of
nuevo
all those
académico,
gathered
así
here,
como a su
this new
introductor
member,
y
as
padrinos,
well
y se
as his
sitúen delante de
introducer
la
and
mesa de
godparents
presidencia.
to sit in front of the president table. Do you rectify the accepting of being part of the Academy? Yes, I do. Do you promise to be faithful and comply with the statutes of the Royal European Academy of Doctors and to contribute with your knowledge and collaboration, both individually and collectively, in order to ensure the prestige of our institution as many times as you are required to it? Yes, I promise. I receive your promise. The Royal European Academy of Doctors is now witness and will be judge of your commitment. I solemnly confirm your appointment as corresponding academician of this institution. You can use the attributes and occupy the public stand. Try to exalt the corporation that today welcomes you and contribute with your contributions on the splendor and honor of letters, sciences, health, arts and techniques, the study and promotion of which have been entrusted to us. The president of the Royal Corporation, Dr. Alfredo Nicolau, and all the excellent academics, all the most excellent authorities, dear friends, and most dear family. First of all, I would like to thank the president of the board to be honored with being part of this institution, which is for me the last step of the faculty and my career. I hope to be for that, and I would like to thank also for the person who helped me to be a member today, and I have a lot of, I'm sorry that he's not here, and I hope that he is well. Also, thank you to my godparents, Joaquín Gironella Goy, and also Dr. Juan Carlos Valdecasas, and I'm sorry that I have to really recognize my proud of for him because he saved the life of my son in the 90s when I met him and we started a friendship, and we are now so as family. And I have to now remember the deceased excellent Dr. Segarra Torres, which I believed he was like a brother to me. He was an excellent teacher that left us a few years ago, and to him in 1980 we had to I did my work in the legal module in the program, And here we have their family, and thank you very much for being here. I'm sorry. I am also really honored to have the opportunity for Jaume Armengol, and because his trajectory as being the first doctor in Spain, he was here in this same scenario, and it was the test of the prolific activity, and first as a business person and then the academic. And he had really spiritual and humanism with his activity. So we can see that in all his publishings, and he is now studying in the cognition. And so we are really thankful for that. Also, thank you very much for all the administratives of the Academy for organizing this act, and everybody for being here as well. So now we will have a speech about the impartiality in the legal act and the contrast of the cognitive bias. You have the floor. So you can visualize now a deliberative hearing, and there's a jury that convinced to decide on the accusation against a 19-year-old boy of multiracial origin for the murder of his father, for a guilty plea which carries to death penalty. It is required to have an unanimity. After a quick vote, 11 of the 12 members vote guilty. Only one of them resists a verdict being issued without throughoutly revealing the facts to have a reasonable doubt. After long hours of debate and successive votes, the jury makes the decision to find the defendant not guilty. It will be remembered, at least by those who come gray hair, that the situation corresponds to the film 12 Angry Men from 1957. The script reflects the personality of each member of the jury, bringing out their prejudices and biases, immersing the viewer in the nature of the human being. As the plot unfolds, it is clear that the interference of the mental process that prejudices and biases produce in us, we can only control, even in part, being part of their existence. And this can only be achieved if prior to the decision, we have decided that we will adopt it in a reflexive way and in a dialogue, such as in the films. Gustav Jung sentenced, the unconscious can reserve essential messages for the ears that know how to listen. End of the quote. I anticipate for a better follow-up of this intervention the doctrinal definition of cognitive bias as a phenomenon that in the mental process and unconsciously produces erroneous interpretation of the available information, influencing in the way of thinking to make judgments and decisions. The movie, the magnificent cinematographic recreation, we can summarizing the introduced intervention also proves us that many of these decisions we adopt, no matter how important they are thoughtless. So that in any other field, when it comes to issuing valuation with legal effects on the or patrimony of others, serious and involuntary errors can be made. The Utopian socialist freedom glossed over the evidence. Justice is human, all human, nothing more than human. And Pope Benedict XVII said that those who are imprisoned for the injustices present in so much of human justice. For his part, Steven Pinker, experimental psychologist and cognitive scientist, constructively we are never going to have a perfect world, but it's not romantic or naive to work for a better one. End of the quote. In this spirit, the booklet that I modestly submit in the academic intends to point and to highlight the incongruencies that we have, because sometimes we must demand the independence and impartiality, and in the other hand, we have to be unaware that cognitive processes interfere in the decisions which threaten that impartiality. And this is not a subject that is thought and considered that can happen. For this reason, I learned from the academy, and precisely because of the interdisciplinary nature, one of its inciting in differential characteristics to submit this work that deals with the evident connection between the law and its application by the human being hostage to its wonderful and mysterious nature. Thus, when we face a transcendent decision, we have to lack the habit of asking ourselves why I think like that. Questioning ourselves in this way would be nothing more than the useful realization of the famous recommendation, know yourself, which appears on the front spires of the entrance of the temple of God Apollo in Delphi. St. Augustine says that the spirit and soul begins in the prophet, saying, "Since I am told to know myself, I cannot suffer that I am stronger to myself," affirming later in chapter 51 that there is no science better than that which man knows himself. Let us discuss our thoughts, words, and works. End of the quote. In the 16th century, humanists such as our eminent and unconsidered Juan Luis Vives insisted on the search for wisdom within man, and Erasmus of Rotterdam, which is the sarcasm and it was a characteristic of him, said that the most pleasant existence consists of not reflecting on anything. A recent experiment did in the Harvard and Virginia University and directed by the psychologist Timothy Wilson thought about a reflection yielded a double conclusion. The most of them had great difficulty concentrating, and that the experience was highly unpleasant for the subject undergoing the experiment. Erasmus said that 6 centuries ahead. I will separate the continuation of my intervention in 3 different blocks. In the first one, I will make an obligatory synthesis of the content of the essay that I submitted to the Academy, and in the second, I will summarize the origin of the evolution of the identification of the phenomenon of the cognitive biases that runs intertwined first with philosophy and then with psychology. And then in the third block, and before concluding, I will refer to the most relevant types of biases in the legal treatment. So for those who know me, don't worry, because my intervention, which is mandatory, everything is scheduled, and there is no risk that it could tire the audience more than strictly necessary. The work is divided into 5 different chapters. The first one, contains an introduction, develops general approach to the legal concepts of independence and impartiality, talking about bribery, prevarication not being the object of study, which because they are conscious of actions of individuals and consequently culpable and considered crimes. The object of the test are circumstances, objective or subjective, that surround the subject that could make him lose his impartiality, even that we can then do a distinction between the concept of independence and impartiality. So the subject concerned may depend on them in their decision. On the other hand, impartiality refers to the possible mental state of the decision maker. This determines how easy it is to establish that one can be independent or partial and adopt a fair decision and vice versa, issue an unfair judgment while being independent and impartial. The law, as it is logical, prohibits the first and requires the second. The highly controversial but eminent German jurist Carl Smith, using the Greek term daimonion, is the inner voice to which the human being listens to, said, the happy success of surgical operation cannot be related to the daimonion of the doctor, or also correct sentences with the daimonion of the judge. End of the quote. In this evidence resides the enormous complexity to prove a subject condition that has not been externalized, despite the fact for years the concept of appearance projected by the subject concerned has been making its way, providing that this generates reasonable doubt about its impartiality. Highly subjective. This entails a very high degree of legal uncertainty, which has given rise to very different resolutions even in the European Court of Human Rights. The second chapter talks about historical legal review from Roman and Hispanic Muslim law to the civil procedure law of 2000. In chapter 3, we have the description of the current legal treatment of impartiality for judges and members of the jury and prosecutors, arbitrators, and arbitration institutions, public administration, with an attention to supervisors and officials within the scope of the national securities and also the tax agency. The regulation in this regard on expert is also addressed. Auditors, witnesses, and finally administrators. Chapter 4 deals with cognitive biases and their influence on the impartiality of the decision maker. And finally, in chapter 5, there are the conclusions. So, having in mind the blindfolded lady of justice, we have the idea that law is applied looking at the facts and not the people transmitting it. To achieve this purpose, the legislator of all times has taken into account the human nature of the judge as a rational and free being, and therefore typifying crimes of bribery and prevarication. However, except for some jurisprudence and very specific causes, I will comment on it later, it is not expressly contemplated by the law that the same human nature, also an involuntary, can make the judge unconsciously lose his condition of impartiality. We have here in Athens Aristotle that the just man is not the one who does not commit any injustice, but the one who, being able to be unfair, does not want to be so. End of the quote. Well, neither the training of judges or other decision makers favors that the avoidance of prejudices and biases, nor the system does. Montesquieu expressed that the just must be mute mouth that pronounces the words of the law. And then Magistrate Javier Hernandez, with an impressive and impeccable track record career, has stated that the judicial decisions come from historical and personal experiences, emotions, moral construction. Judges act with cultural software that feeds on prejudices and ideological or meta-normative judgments that often hibernate sheltered from the specific process. End of the quote. So the clarity and the evidence of this quote contacts with the fact that competitive examinations for the judicial career are still relevant subjects in the part of the agenda, nor is any subject of preparation given to the future judges or how to take into account that a few days ago, a magistrate's speech on the occasion of Doctor Honoris Causa in the University of Zaragoza, highly prestigious magistrate of the Supreme Court, member of this government chamber, Mr. Ignacio Sancho Gargallo, one of the few members of the judiciary who has paid attention to the cognitive bias, had an impact in the same direction as the Judge Javier Hernandez, who instead pointing out the need for judges to be aware of their existence and let them fight against them for their defense. Allow me to add that in order to be successful in this fight, it is necessary that the study plans and training of the future of judges dedicate the necessary attention to such an important matter. Self-learning about the control of the mental processes in such an important field seems insufficient. To underline the importance of the issue, allow me to talk about provide a few ideas about the origin, evolution, and current state of the science that has led to the identification of cognitive biases and their effects. Everything related to the mental process has been occupying the philosophers and since the classic times. Plato, Aristotle, Pharisaic, he then Cicero having the mind and talking about how to be the first one to define the concept of intelligence. And there are some authors, such as Seneca, or we have some reflections on fear and the anticipation of pain written in letters to Lucilio. Then we have scholastics such as Saint Augustine, Clement of Alexandria, Beatus Scout of Erigena, and St. Thomas established the importance of exercising understanding and reason. Studying the psyche, the Persian Avinci and the Cordovan Averroes who lived respectively in the century 10 and 12. To observe this in the West, in the periods prior to the emergence of the rationalism, prevailing beliefs, and then consequently with the analysis of thought, did not predispose to these studies since they were associated with witchcraft or demonic interventions. With this abandonment in this time of the history, there was a big band as a result of the advance of studies on mental processes with unstoppable. This was until centuries 17 and 18, where rationalism sinked in, and Plato was talking about Descartes, and we identified the biases and talking about that it is too weak and limited mind of man, and he talked about idols, and then we had John Locke, influenced by the epistemology of our Francisco Suarez, distinguished between simple ideas whose source is the sensation and they arise from a passive creation in the mind after the sensorial perception. These are really simple ideas and we have to study it. And this was the beginning of the study of thought. We have the philosopher and economist David Hume restricted all knowledge to impressions and ideas, holding that passions and emotions govern human behavior much more than reason. Huxley, in full enlightenment, in observations on man, his frame, his beauty, and his expectations, fully developed what is now known as associationism in the thought process. They were close to arriving at heretics. Wundt already in the 19th century studied the psychology of consciousness in contrast to unconscious development. And then bringing psychology closer to science and studying the relationship between the nervous system and behavior, building the bridge between neuroscience and psychology. All of this together with the studies on biological and sociological behaviors now in the centuries 20 and 19 are the foundations for the identification of phenomenology. We have now a person that is fully aware of his own reasonings. This idea is broken with the development of economic science and studies on consumer impulses making purchase decisions. Thus, in 1947, the economist Herbert Simon, in Administrative Behavior, a study of a decision-making process in administrative organization, openly questions that the decision-making processes is based on rationality, which led him to support the concept of bounded rationality. In his book, Models of Man, he established that the majority of human beings are only partially rational and that we act according to emotional impulses through a process that is characterized by intuitive decisions, counting on incomplete information, although it is always looking for a solution that is satisfactory to us. After Herbert, the Nobel Prize winner Daniel Kahneman described an extremely simple way the two different ways in which the mind creates thought. System 1, fast, conscious, and generating intuitions, and System 2, which is lazy, slow, and requires effort. And then logical, observing and controlling the intuition. In the recent article, Blind Justice, the curious experiments that show how biases affect judges, various observations are collected that offer a disturbing panorama. One of the experiments carried out by Columbia University draws since 1,112 decisions on parole issued by 8 Israeli judges, it was shown in a vast majority of cases that they were more inclined to grant conditional freedom, after a lunch break, regardless of the liability of the study to aim to conclude that the direct causality between hunger and decision, the scientific community has no doubt that the biomechanical processes that occur in our body can also affect our or bias our decisions in a totally unconscious way and determine a concrete conduct. In this way, behavioral psychology has established that in addition to prejudice in any human decision, and as a result of laziness, we use mental shortcuts. Because sometimes we don't have instruction of the person concerned in a violational act of judging, and all part of the information that has been received and has accumulated in the unconscious interference. This is an interference on the mental process of evaluating the information. Starting from this background, it is also known that in Spain, the law is anchored in an exasperating formalism and rigor that is also inbred, acting behind the back, or at least with an apathetic delay to everything that other sciences can contribute today, including psychology. The theme in this question is the clear exponent and contrast with what happens with neurosciences and other subjects that advance in the interdisciplinary way. A magnificent example of the last statement can be found in the so-called Brain Project, an initiative by the Spanish neurobiologist Rafael Yuste, which in the United States rushed to support with huge funds and which brings together science from many different disciplines and has as a goal to create a brain map containing between 80,000 and 100,000 million neurons with about 10,000 connections each. Justice undoubtedly is advancing slowly with the revolution of online communication systems and will also be inflected by artificial intelligence, regardless the fact as a minority report, which turns out to be a reality. Thus, in 1998, we used the Compass program as a legal assistance tool in North American courts. This program reviews, according to certain impairments, the possibility that a specific individual who has been convicted in various proceedings re-offend a crime. However, compared to the judge's rulings, the program offers a similar number of errors, since biases also lurk whoever established the program's algorithm. In this situation described, which leads to conclude that there are really quickly reached with when it is verified treating our regulation and jurisprudence, in a very short way, as to fit the ideological bias caused 10 Article 219 of the Organic Law of Judiciary, having a direct or indirect interest in the lawsuit or cause, and it is simply an indirect collection of pretending to avoid it. The possible existence of the so-called confirmation bias, on which I will after reflect, and I now cite having participated in the investigation of the criminal case or having resolved the lawsuit or cause in a previous instance. Next, and I'm obliged to say that to make some technical legal notes on two different resolutions regarding this last cause of abstention issued by the Supreme Court in proceedings related to the unilateral Declaration of Independence of 2017, which to this notary importance and novelty I should not ignore. In this main proceeding on the crime of sedition that culminated on a very elaborate, in my humble opinion, technically impeccable sentence in 2019, we have the challenge was rejected, among many others, based on the defenses in the participation of the members of the trial chamber, resolving petitions from the defendants regarding their presence after having received the records once the investigation had finished and prior to the trial, as determined by the Article 502 of the Criminal Procedure Law. However, those members of the chamber could not have been prosecuted if they had resolved an appeal against a resolution of the lower court on the same, precisely because of the provisions of the aforementioned cause of abstention or change. I have to say that this logical reasoning of the chamber and its resolution denying challenge, which fully complies with the regulation, highlights a certain legislative inconsistency and paradox in despite the fact that it was mere confirmation that the trial chamber of what was agreed by the investigation magistrate. The chamber had no other alternative in its decision on this specific challenge. The responsibility for the situation, as in many other cases, falls on the legislators and not the judges. And of a court, it is not about interference or political or ideological nature, but merely technical and legislative interpretation. With the same purpose, I will proceed to make brief, highly respected reflections to contrast what I just mentioned on the very recent ruling also on confirmation bias of November 10 of the Supreme Court, which says that it is obliged for the members of the Parliament Committee of Catalonia to repeat the trial also on the occasion of the unilateral Declaration of Independence. I contrast this last sentence with this indicated in 2019. There is a great complexity on the issue. So let's see. The Supreme Court understands that two members of the chamber, which could have produced the so-called horizontal contamination to the rest of its components, who acquainted several defendants and sentenced others for certain decisions of the Parliament of Catalonia, could be found predetermined at the time of issuing a sentence for having resolved the admission to process the complaint that started the procedure and subsequently rejecting the appeal by the order of March 16, 2017. It has been pacifying then the European Court of Human Rights with the doctrine established in 1994 in the case Saraiva de Carvalho against Portugal, except for the pathological cases in the admission. And we see that the bias in the admission only verifies indicatively: one, if the crime is described; two, if the complaint meets the rest of the requirements established by the criminal procedure law, and in the order for the admissions of the complaint of February 2017, the Superior Court of Justice of Catalonia did so, and in my opinion, it based its decision on an impeccable resolution, taking care to reiterate upon 4 times, and then in the order of March 16, 27, resolving the appeal, indicating up to 9 times that it was a very initial assessment and it was successful. And they say, therefore, this resolution does not assume at all each of the factual and legal assessment contained in the complaint. End of the quote. This need for substantiation in the admission of the complaint is established by the sentence of 2016, recalling a previous one from 2015 that established the absence of the prior examinations to which the court is obliged, or it is completion without including in the connection of the behaviors prosecuted with the content of fundamental rights and public liberties. It is not constitutionally admissible. End of the quote. Well, the sentence of November 10, accepting the correction of the order for admission to proceeding and without questioning the final sentence, going further than ever, has understood that the content of the resolution admitted to complaint dealt with essential issues and it is implied bias and contamination at the time of sentencing. In this doctrine, it is considered that, with no doubt, that legislative change has to be self-respecting complaint must be based on highlighting precisely the essential issues that determine the indicative existence of a criminal commission. But this doctrine would make that appeal for replacement reform an appeal that are feels before the same laws, these laws meaning, and other judges should be the ones to solve them. It seems clear that the decision to go to prison in the first case, in the 17th sentence, to have the admission of complaint about the bias of the indicative existence of crime. The arduous work of the Supreme Court issues such a formant is notable, and this latest sentence can be praised for what it implies in terms of increased guarantees. But we have to ask ourselves if the European Court of Human Rights itself has not generated a sentence impregnated with some type of unconscious convenience bias. I will now refer to the main bias identified. Only Kahneman identified in the middle part, in the century of in the middle of the 20th centuries, 137 types of bias, and I will talk about them with no order. I will talk about referring the confirmation bias, which is referred to the subject unconsciously or with very little awareness of it has internalized what his decision will be, proceeding throughout the deductive process to offer, estimate, or accept the information and evidence that supports his initial thesis. And Schopenhauer described this trend by saying, the majority of men are not capable of thinking, but only believing, and they are not accessible to reason. End of quote. The English psychologist Stuart Stuttleman stated the monograph Irrationality, the enemy within that. The unwillingness to renounce one's opinion is a characteristic of all professions and social conditions. Our opinions are extremely resistant to change. End of quote. And following the illustrious mathematician and physicist Karl Popper, considering the greatest philosophers of the 20th century, about his studies on falsificationism and established that any empirical science theory can never be proven, but can be falsified. He also maintained, in relationship to forgetting refutation as the only way to confirm a belief, that to determine the probability that the rule is true, one must therefore try to show that it is false, which is precisely what is not done. End of quote. It seems that these words have to do with self-esteem or pride, but recently the British neurologist Sachs goes much further and says, undermining one's own beliefs and theories can be a very painful and even frightening process, because our mental lives are sustained consciously or unconsciously by theories sometimes invested with the force of or the strength of ideology or delusion. In 1958, Perman and collaboration said, the man with preconceived ideas is therefore partial, not only because he has taken sides, but because he can only use the part of the pertinent arguments that is favorable to him. with which the others are left, so to speak, frozen and in the cold. So the anchoring bias is described when the subject is making the decision makes an estimate based on the certain initial fact. It is what commonly called the first impression. For its part, the study of group bias is associated with anthropology and the famous dilemma, good man or bad man by nature. This bias is closely related to the ideological bias since it is the cause of it. Group and mass psychology and sociology explains to us in certain and numerous circumstances the relational influence to which a man is subjected can come to shape or transform his way of thinking and consequently his behavior. And in the words of socialist Le Bon in 1895, Psychology of the Masses, we can read that these are endowed man with a kind of collective soul, which makes him act in a completely different way from how each one of them would feel, think, and act in isolation. The phenomenon associated with the fading of personal consciousness that can lead to the individual to calm horrors derived from excesses, among many others, due to religious beliefs or racist sentiments. No other better to explain the phenomena than Hannah Arendt or the occasion of 1961 trial in the Nazi Hartmann, identifying in the book she wrote. This notable Jewish philosopher received much criticism as she maintained that this man was simply a bureaucrat. He didn't hate Jews, he just admired Hitler and followed orders. And then Stanley Milgram, in his work, The Danger of Obedience, along with other later ones, also talked about how, about Arendt. We have also the monograph Imperios of Crueldad of Alejandro Rodriguez. He talks about how the attention to the fact of ancient phenomena, ordinary human beings are capable of reaching extreme levels of cruelty towards their fellow men. It is easy to conclude that in decisions of much less importance, he can decide and act influenced by a group bias. So much as said about politically correct, but it turns out that society, for the most part, gradually assumes its values, which subtle permeate our own thinking, as Zygmunt graphically established in 2000 as a reflection of liquid modernity. But what matters here is that not only does the legislator end up succumbing to the prevailing thought, but that his affects specific decision of judges and courts in the interpretation of positive laws. He said that the group bias determines the ideological bias. Well, then we have to talk about distinguish the prejudice of social, class, politics, race, religion, sex from cognitive bias. Because in the first one, it's common that human beings to be aware of our own voluntary beliefs, but biases operate unconsciously in the mental process when deciding or opting for a certain alternative. However, it is evident for what is peaceful that a prejudice can determine a bias, which is why ideological interference in the mental process is called as such. It is attributed to Albert Einstein the sentence that it is easier to disintegrate an atom than a prejudice. The ideological bias, according to the organic law of judiciary, can only be accommodated in the clause 10 of the indicated Article 219, having a direct or indirect interest in the lawsuit or cause. This bias is the most dealt with by all the courts, although it generates judgments loaded with individual votes, whatever their meaning, which reflects different sensitives. This is produced by the collision of two rights: the one of the judge himself to have ideology and to have impartiality. To appreciate the violation of the last right, it is enough and has been expressed directly and indirectly. And to give an example, a judge can be sexist or racist, but if he does not express it in any way, the system does not consider him lacking of impartiality. In this case, the cases are great since not every externalization of thought can validly justify a challenge or even an abstention. With what has just been highlighted, one can appreciate once again the complexity that all this entails. And with respect to the bias, it's worth asking if a certain expression made by a magistrate outside the chamber in defense of the constitutional order or his demonstration of rejection against an insult against the state or its institutions that the judges have promised or sworn to defend can mean some appearance of the impartiality in trials in which the attack against the constitutional order and its defender judge seems the appearance in the regards. It is not only evident, but its very essence in which the judges do. Hence, in my opinion, we have the demonstration of the repudiation of the statesman that Spain is a state that maintains political prisoners should not imply subsequent cause for recusal when otherwise judged due to prejudice of any kind or ideological nature. We cannot have judges, whatever they say it or not, who are oblivious to the attacks on the order that they precisely have the obligation to defend. This is an obvious contradiction that would imply, in an extreme example, being able to have grounds for recusal in any prosecution of crimes against the constitutional order or before states institution against all judges because all have promised or sworn to defend the Constitution. The affinity bias, which some authors try to give its own entity, in my opinion, it is part of the group bias because we have to the best disposition to those people who understand that are related to us. And here we have the halo effect and the opposite, the pariah effect. For the first, we attribute to certain people positive characteristics generated by the first of them that we observe as something that pleases us, such as the supported by numbers studies that of attractiveness that can lead to conclude that the person is intelligent, friendly, and honest. The pariah effect produces the opposite, generating widespread rejection for the first characteristics that we observe of the person. I will now talk about representative bias, in which it is explains where the subject starts from the statistics, probabilities, or from the personal intuitive perception of these to establish that an event will occur. To exemplify this, it is more probable that we roll two dice, we will get a 6, then we will get 2 6s. But actually, the probability is identical for any combination. Thus, if the person being investigated has a record for theft and is accused precisely of a new crime of this type, it can be concluded that it is more likely that this subject is the one who has stolen again, rather than other who is also being investigated but has no criminal record. The error generates this bias, is prosecuted, and it is the conclusions of the experts on the matters that doing that, based on statistical or probabilistic reasons, support other mere indications that point to guilt. The case is a parody. This is a paradox. It is an English case, Sally Clark, prosecuted in 1999 for the murder of her 2 children. One, she was 8 weeks, and then the other 11 weeks old. It was a double case of sudden infant death syndrome produced by cardiorespiratory arrest of unknown origin. However, the probabilistic of a statistical calculation made by the experts that this happened in 2 children of the same mother offered an absolutely improbable result close to 0. It was concluded that the deaths of the children had to be in the intervention of the mother, Sally Clark. After years in prison, she was released after review of the sentence promoted with the contribution of the other reports of the Royal Statistical Society. Finishing with the biases, we have the one of convenience. The thesis of rational choice between alternatives assumes that the human being tends to maximize their utility or benefit and reduce the costs or risks. For the most part, every individual is rationally guided by their personal interests, that of their relatives or that in the group, in coexistence with other motivations and emotions, and with the containment of the principles and values that permeate their determined personality may foster. The subject makes the decisions without acknowledging it internally because he does not want to deal with or does not know how to do it. And as a specialty of convenience, the so-called Beckett effect, also known as loyalty or reciprocity bias. This is described when a person is designated for a specific position or function, assuming that they will be bound by loyalty to the person, institution, or reorganization, and has appointed to them that they have to supervise, control, and this also has also make decisions that could affect the person who has appointed him. It makes its name from Thomas Becket, Archbishop of Canterbury and appointed Lord Chancellor by Henry II of England, as well as the confrontation with the king in which Becket put before he was considered to be his obligation due to loyalty and cost his life in 1170. This bias is displayed with particular importance of the great frequency in public functions. For some time now in Spain, at the forefront of the debate of the appointment current government of the magistrate and the constitutional court, because of the relevance of the members and also because the enormous relevance in relation to the independence and impartiality of such institutions receives extensive attention from the media and from Brussels. However, it is hardly deserves consideration that the changing government have the power to appoint and dismiss the presidents of regulatory and supervisory bodies, such as among many others. For example, national security market commissions, national commissions of markets and competitions, just to say some. And this can be used by someone that who could be totally out of the system and establishing its immobility except for very justified reasons during the duration of their mandate. In short, the convenience or reciprocity bias generates manifest themselves openly or underlie without emerging externally or internally in the conscious. How many of us, even in minor situations where life was not at stake, would be able to act as Beckett? I conclude affecting any subject or any decision, cognitive bias is an undeniable reality of practically non-existent consideration in law, which is sought sometimes seriously, both judicial and arbitration procedures, and the decisions that act of any legal operator, who most of the time acting with the commitment and dedication of its profession and even trusting that he acts correctly is unconsciously, like any human being subjected to the interference of bias in his decision that affect the alleged impartiality. The common citizens don't know about this bias, and nothing is farther from reality in this area, as I have allowed myself to point out. But it is more remarkable due to the irrelevance of the matter that there is no authentic and effective debate or concern, neither at legislative, jurisprudential, doctrinal level by legal operators, and even less by the recipients of the norms that we turn out to be all citizens. The concern shown by the Honorable Judge Sancho Gargallo that I have cited should be an example to follow. The panorama is disturbing and complex for those who observe the situation objectively, and we can say that most humans live with our backs turned to our minds and to how our thinking is formed, since regardless of prejudices and bias, we do not usually take into account the effects of biochemistry that interferes with brain processes such as cortisol, serotonin, oxytocin, dopamine, among others, whose effects, as has been fully demonstrated, have very relevant influence on our decision making. For this, it is means that in the educational system there is no minimum training, just in the natural science, the human body, or the natural that surrounds us is studied. On the consequences in the decision-making process of prejudices, biases, or substances that we segregate according to our physical or mental situation. As I have been pointing out, the normative system is highly improbable and lines of work are indicated in the paper, but this is not enough if the changes of the subject themselves do not take into account the individual dimension in the light of modern psychology and neuroscience. In the United States, the progress has been made in the detection of prejudices and biases in judges through psychotechnical tests and periodic interviews. In short, if prejudices and cognitive biases are important in the field of human activity, in law they are even more important because the decision interfered with by them implies direct effects on the lives and assets of others, trusting both and the decision makers and the recipients of the trials in an impartiality that is the end can be seriously undermined. Nothing better to express that uh, as the words of the magistrate Sancho Gargallo contained in the article published in 2020. And I quote, cultivating self-awareness and questioning whether I may be affected by any bias or prejudice is key to being able to appreciate when and how a certain bias or prejudice is affecting my judgment. In fact, it is usually concluded that the most dangerous bias that lurks a judge, I allow myself to add that to the quote, is the presumption of thinking that he is immune to any bias. Being aware of having an end of the quote, sorry. Being aware that we have a complex and disturbing panorama and that we can improve and has an immense majority of vocational judges sacrifice and deliver to the difficult function of impairing justice, they do it without receiving the recognition of society. I don't know how my beloved Spain would be without them. So thank you very much. I give the floor the academician, member of the Royal European Academy of Doctors, Mr. Dr. Jaume Armengou Oruz, who will answer on behalf of the Royal Corporation of the session of the new academician. Excellent Mr. President, Excellencies academics, most excellent and illustrious authorities, ladies and gentlemen. Now, I have the honor of answering the admission speech of Dr. Enrique Morera Guajardo in the Royal European Academy of Doctors. First of all, I would like to express my gratitude to the corporation and more specifically to the President, Mr. Alfredo Rocafort Nicolau, and to the board directors. Likewise, I would like to thank Dr. Enrique Morera for having thought of me to comply with this mandatory and daring custom. I am also honored that His Excellent Dr. José Antonio Segarra Torres, who joined this corporation in 2016, would now be in my place, had he not left us a few years ago. Other aspects of the order contribute significantly to the honor of the invitation. I highlighted, first of all, the personal and professional level of the recipient. I remember having a conversation with Dr. Morera that are remembered as special enriching conversations that encourage change in deeply rooted points of view. Some of these dialogues topics have permeated the discourse that follows. Dr. Enrique Morera has been my professor at IESE, and I remember with precision, his solidity and exceptional capacity of persuasion and communication, including his mastery of the classroom, no doubt trained by the practice of the legal profession. It is already started with these words, the mandatory description of the curriculum. This personal professional profile cannot be satisfied without journey, reaching study, practice, research, and confrontation with opposing points of view. Dr. Morera has a law degree from the University of Barcelona, a master's degree from the Insurance Law Institute, and master's degree in business law from Barcelona Law Society, an MBA from IESE, and he is a doctor in law and political science from the University of Barcelona, and as you can see, an academician of the Royal Academy. He is the founding partner of the firm Balaguer Morera and Associados and he offers services in Barcelona and Madrid regarding commercial, corporate, contractual, and bankruptcy, judicial arbitration, administrative law, and its legal procedures on economics, financial aspects. And he also directed relevant and well-known cases in the criminal, economic, tax, and inheritance law fields. As a lawyer, he has more than 40 years of professional experience providing legal and business advice and services directly or directing their firms professionals. He has been an associate professor at IESE for more than 30 years, and he's a member of the board of directors of different companies in different sectors in industry, commerce, transport, communication, real estate, financial, etc. He's a president of DISA, and he is dedicated in the sale of fasteners for industry, agriculture, and construction. He is also president of two family offices. He has led corporate operations worth several billions of euros in processes of acquisition, divestment, mergers, spin-offs, dissolutions, liquidations, conflicts, and separation of partners, and startups. Among others, the launch of the PortAventura theme park, the acquisition of listing of Antena 3, or the incorporation on listing of Vueling Airlines, of which he was General Secretary until its acquisition by Iberia. Apart from the numerous direct actions before the judicial and arbitration courts, he has directly or supervised, with the support of professionals, BMA firm, thousands of judicial procedures in different instances, national and internationally. There lies the true and enormous technical research regarding of publications. The procedures before the European Court of Human Rights stands out, in which the Kingdom of Spain was condemned for violation of the Constitutional Court of the Fundamental Rights itself. Similarly, he has intervened in multiple arbitration proceedings, obtained notable announcement sentences, which are now being studied in the faculties. He has extensive experience in the real estate market and in the urban law. Its multiple publications could not have been written with the richness that they harbored if were not for a very diverse trajectory. We will highlight a few. Without being the first time, but rather a publication that necessarily requires maturity, the doctoral thesis entitled The Regulation of Unorganized Securities Market Specific Study of the Total Return Swap, defended at the University of Barcelona with a cum laude rating. As works that can be grouped due to their impact on the training of a large number of managers, I mentioned some of his publications with or without co-authorship that are used or offered by IESE. Report on the general shareholders meetings in IBEX 35 companies 2013, legal liability of administrators, executives and partners, debt or crisis and insolvency, the bankruptcy, mercantile companies, the promises note, the bill of change. Other notable publications are responsibility, legal concepts and singularities, Editorial Ariel, Public Administration, Social Cohesion and Territorial Cohesion, Universitat de Barcelona. In addition to numerous articles published in various media on legal, political, and historical issues, he had given numerous conferences or communications in many different institutions, small shareholders, Universitat de Catalunya, IESI, Col·legi de Censors Jurats de Catalunya, Illustrious of College of Attorneys of the Court of Barcelona. In summary, we can talk about a person who is in love with law and, according to the Dr. Morera, must be approached in the professional practice in an integral way due to the interrelation of its disciplines, which is why we are dealing with someone indefinitely far removed from the barbaric specialist that Ortega and Gasset, avid reader, devoted to Cicero, and with an insatiable desire for knowledge capable of expressing itself in various conceptual and idiomatic registers, with arrests to face in court the kingdom of Spain itself and the tax agency, loyal defender of his client, jurist, humanist, financial manager, husband, father, and grandfather, passionate about bridge and chess fun for what they imply. He also transformed Sparks Public Limited Company, later being its legal advisor 8 years until year 2000. Creative, tenacious, with an unparalleled legal imagination, according to Joan Ginebra, former general director of IESA. He and I have talked several times soul to soul about the risk of rudeness inherent in the human profile when it comes to the relationship with different personal profiles. And it is a regression to the mean, it is impeccable. As extraordinary as it may seem, the recipient is one of its kind. I'm sorry, Henry. Welcome to the Royal European Academy of Doctors. Dr. Morera's admission speech is impeccably structured. It introduces the topic, makes a historical review, and a review of the current state, then goes on and addresses the topic titled Cognitive Bias, its influence on the impartiality of the decision maker. It ends with the chapters of the conclusion and bibliography. Apart from the structure as the essay, it is worth noting the discursive strategy. In one hand, he used example to give more references and support the flow of information, but even more so, it highlights the interest that is being generated. It intrigues, and we could say by progressively discovering the relevance of the object of the study, the cognitive bias, and the danger it poses to the independence and impartiality of legal decision makers. In this way, when the central chapter is reached, the reader is eager to know the result of the investigation, the answer to the hypothesis raised, the conclusion reached, the ways to mitigate risk. A few extracts from the speech are enough to justify what I have just said. So I first quote the first paragraph of the essay in which the challenge is identified. It follows. It is easy to agree the impartiality and independence of whoever administers justice or issues judgment or opinion as a function to which the law grants legal effects forms one of the essential pillars of a democratic state, for which reason it is analysis leads to one of the biggest challenges in law. Later, the, we say that it's not a single discipline approach, which shows the courage and erudition of Dr. Morera in his decision to face his object of study. Indirectly, it will also become clear that this approach requires an international vision. Finally, in order to limit the objective of study, he says, in this essay, the concepts of impartiality and independence will not be addressed in the full scope. The work is circumstanced precisely of the problem in relationship to bias that can influence to which no one is oblivious in the mind of the judge or court. In other words, the issue is relevant because it makes the democratic state vulnerable and requires a multidisciplinary and international approach. But the relevance does not seem to be recognized. I quote Dr. Morera again, reiterating what he has just explained. This reality is unknown to such an extent that neither in the oppositions nor to the judicial career, nor in the school In law school, such a relevant subject is part of the agenda, nor in any subject or preparation taught on the psychological processes aimed at decision making. In his speech to explain the reason for bias, Dr. Morera turns to Nobel Prize winner Daniel Kahneman, the latter with great didactic sense, and explains that human has two different systems, system 1 and system 2, and we could say that this first system is quick and effortlessly, and the other one is reflective. The first one is spontaneous and provides information really fast. The second one needs more time to reflect. And even when the maker is well intentioned and has time to analyze possible alternatives to a decision, the first system really influences the second. This is the way Kahneman models the decision making process and the generation of inadvertent errors. That mistake of someone who sticks to reflect, who is eager to find the truth and be fair, who does not allow himself to be influenced, at least voluntarily, by his emotions, is cognitive bias. But it is clear that there are ways to identify bias, such as questioning one's assumptions, analyzing alternatives to a decision without ruling them out prematurely, listening to opposing voices, recognizing and analyzing errors, apologizing, etc. This being the case, and listening to the classics, we could say that the possible types of ignorance. In the case of someone with a solid legal background, the bound to independence and impartiality, ignorance is necessary. We have, and this gives greater relevance to the research. Bias affects judges, but also others, such as officials, experts, auditors, witnesses, administrators, capital companies. It affects all professions, human behavior. Bias is present in history, but also in literature, painting, theater, cinema, etc. Don Quixote is biased, confusing windmills with giants. In Airway Flight 1549 that took off in January 15 in 2009 from LaGuardia Airport bound for Charlotte International Airport. Less than 2 minutes into the flight, the Airbus collided with a flock of geese, damaging both engines and leaving it dead. No propulsion. The A320 splashed down in the Hudson River. All the passengers were rescued. The film that recounts this event, Sally, is about a bias. With the support of experts, the judge wants to know if the plane could have flown to the nearest airport or not. For this, there was a flight without propulsion, and it simulated with the impact of the flock, and the plane arrives at the airport. But this simulation is done with having information that was not available in the real case about the level of damage caused by the ducts to the engines. And the best decision to make, if the time needed to learn and make the decision is just few seconds, is to take the plane to the nearest place to land. Sully is not only innocent but a hero. What is the bias? It is the hindsight bias, using information for the deliberation that could not be required at the very moment that the events occur. Holy Scripture accept has at least one of these bias. A good man is a person who could say, totes taponen. He was doing well personally, family, professionally, and spiritually. But from a certain moment, everything starts to go wrong. And a debate begins with wise friends who will tell them that he is doing something bad. It is because he has done something wrong. He is guilty. But then finally, God intervenes in the debate, and it becomes clear that he is loyal and he has not doing anything wrong. He is not being subjected to punishment, but to be tested. He is innocent. Job, he passes the job and he is not, and he will be rewarded. His wise friends are not punished for having biased the prejudged Job, thanks to Job's prayers on their behalf. Offer a burnt offering for yourself, and my servant Job will pray for you. For surely I will pay attention to him so as not to treat you shamefully. They are found guilty of bias, of lack of righteousness. Commenting on the Book of Job, Chesterton writes that the main intellectual beauty of the book is that it is all about the desire to know reality and not only what it seems. And so, one after another, we could be describing biases that affect decisions in all areas of human endeavor, including the legal field. There is an aggravating circumstance of being defenseless due to the ignorance of vulnerability to bias, which a negative learning, when the reflective system repeats decisions, it learns and it gradually converts reflective deliberations into spontaneous ones. A simple example is to learn how to write. It is difficult for a child to decipher what those drawings are, but with time, reading happens spontaneously. He has developed positive learning. You learn to do good with greater perfection and less effort. Because learning can also be negative. It happens with mistakes when are doing mistakes spontaneously without effort or reflection. In this case, bias repeated erroneous decisions after the respective reflections become automated. They become spontaneous, and the error is even justified a posteriori, reflexively, and without any awareness. I'm not going to lengthen, so in the treatment that Dr. Morera has given to the concepts of cognitive bias, the courage and humility with which he approaches the phenomenon are just a few samples, but these samples are on the other similar aspects that emerge throughout the discourse, added to his career, personal and professional, together with the relevance of the subject, constitute for me irrefutable proof that of the success of his incorporation into the Royal European Academy of Doctors and a preview of what his subsequent contributions will be throughout the years to come. I beg Dr. José María Simonton, emeritus academician and member of the Senate of the Royal European Academy of Doctors, to deliver the diploma to the new academician. Excellent Dr. Enrique Morera Guajardo. It's for me a satisfaction and a real honor to be here with the President, with the right to give you, in name of the Royal Academy, the diploma that says that you are a member of this Royal Corporate, this Royal Foundation, and we, in the presence and attention, contributed to enhance the solemn reception public in this prestigious academy. Congratulations. If we wanted to take a retrospective journey to discover our academic roots through the doctorate, we should enter the cathedrals and their cloisters from which the universities and the passion for teaching and learning were born. Doctors, professors, and magistrates trained the new generations through scholasticism or doctoral doctrine. Thus, it is discovered that being part of the Royal European Academy of Doctors means that our specific way of being academics is to be interdisciplinary doctors coming from all branches of knowledge. Being an academic means belonging to a group of intellectuals who responsibly think about the present historical moment through scientific research. Being an academic is, therefore, in the first place, to be a witness and testimony of our historical moment. We cannot speak of the present as something that is about to be packed and exhibited in a showcase in front of the past, but we will reflect on the past to make it present so that it provides us with options for the future, because in the future lies life and hope. In this balance, through which we take the pulse of time, our critical task will be none other than the one of the selection and the filter. Today, we are witnessing times of change and turbulence. In the effort to find solutions, it will be necessary for us to be risky and be rooted in scientific research, which is our task. We can only be interdisciplinary. The Royal European Academy of Doctors is based on this multiple scientific experience. Its members, from among other sciences, law and economics, medicine and psychology, physics, chemistry, and engineering, geography, and anthropology make up a bundle of research paths that, although they start from this polytheral perspective of reality, they aspire to build a meeting knowledge about nature and culture in which man can inhabit. It is therefore a European-wide corporation that does not find an institution with similar characteristics in Spain or in any other country of the European Union. Our Academy wants to recognize the merit of those who have excelled in their service to science or to society. If you look closely, this objective has been part of the life of the Academy since the starting of it in 1914 with the appointment of the first academicians. It is possible to be an academic from the sedimentation of the scientific biography, already in full intellectual maturity and in full teaching and research capacity. The mission of the Academy should be none other than to access the truth, to defend life, to work on science, and to proclaim intercultural coexistence. This is why the Royal European Academy of Doctors has set its main goals to offer answers to global challenges, to influence and connect people, institutions, and organizations that share our values, to transfer today's knowledge to tomorrow's generations, to develop our networking that connects with the best talent. One of the hallmarks that characterizes the Royal European Academy of Doctors is the presence in our sessions of personalities awarded with the Nobel Prize as the maximum expression of those scientists who have been recognized for their academic merits by the international community. This is confirmed by the 21 honorary academicians of the Royal Academy who have been awarded by this distinction and who honor us with their regular participations in our events. So 4 Nobel Prizes in economics, 5 Nobel Prizes in physics, 6 Nobel Prizes in chemistry, 3 in medicine, 2 Nobel Prizes in physiology, and 1 Nobel Peace
con el deseo
Prize.
de dar a conocer mejor a nuestra institución.
On the other
quiero hacer
hand, with the
mención
desire
del
to make
último
our
Congreso
institution known
Internacional
better, I would
organizado
like
por
to
la Real
mention the
Academia
last
Europea de
international
Doctores.
congress organized by the Royal European Academy of Doctors.
El sexto Congreso
This is
Internacional en Ecuador.
the sixth
Primera
International
expedición
Congress in
científica y
Ecuador,
cultural a las Islas
first
Galápagos,
scientific and cultural
Quito y
expedition
Guayaquil,
to the Galapagos
celebrado
Islands,
del 25
Quito
de
and
agosto
Guayaquil,
al 6 de
held
septiembre
from
de
August 25
con la
to
estrecha
September 6,
vinculación de la académica de
2022,
honor y
with a
expresidente de
close
Ecuador,
relationship of the
Rosalía Arteaga.
honorary
Tanto en
academic
la
and former
Universidad de San
president of
Francisco de
Ecuador,
Quito
Rosalía
como a
Arteaga,
bordo del
both at the
barco del
University
National
of San
Geographic
Francisco de
Endeavour
Quito and
II,
board of
se
the
ha
National
presentado
Geographic Endeavour
un
II,
programa científico
it
donde
was
se incluyeron
presented a scientific
debates,
program
mesas redondas y
that
conferencias
included debates,
en el que
roundtables,
compartimos
and
conocimiento,
conferences in which we
pensamiento y
shared
reflexiones
knowledge,
en un ámbito
thought,
multidisciplinar,
reflection in a
gracias a la mayor
multidisciplinary
pluralidad de
environment thanks to the
científicos,
unique
premios Nobel,
meeting of
artistas,
scientists, Nobel
empresarios,
Prize winners,
defensores del medio
artists,
ambiente y docentes universitarios.
businessmen,
Esta
environmental
iniciativa se enmarca en
defenders,
el plan de
and
acción de la Real
university
Academia
professors.
dedicado
This initiative is
al
part of
medio
the action
ambiente,
plan of the Royal Academy
sostenibilidad
dedicated to
y
the
cambio
environment,
climático, como
sustainability,
reflejo
and
de
climate
nuestra
change as a
preocupación
reflection
ambiental.
of our
Es por
scientific
ello que
concern.
en este
This
Congreso
is
se
why
elaboró un
this
manifiesto
Congress
declaración
drew
que
up a
desde la Real
manifesto
Academia se quiere
declaration that the
compartir
Royal
con las
Academy wants to
organizaciones
share
internacionales
with the
responsables
responsible
y
international
debatir
organization
los
and
problemas
to
del cambio
debate the
climático.
problems on climate change.
Del mismo modo,
In the same
quisiera
way,
invitar a todas las
I would
personas
like to
aquí
invite
presentes
all the people
y a las que
present
nos
here
están siguiendo
and
de
those
forma
who are
telemática
following us
que también
electronically
sean
to
partícipes de
also
esta iniciativa
participate in this
firmando este
initiative
manifiesto.
by signing this
Se puede
manifesto.
encontrar en la
It
web de
can
la
be
Real
found
Academia
on the Royal
o
Academy
bien
website
escaneando el código QR
or
que
by
podrán
scanning a
encontrar
QR
en la
code
salida
that you
de
can
la sala.
find in the exit of the room.
Actualmente, la Real Academia ya
Currently,
está
the
preparando
Royal
el séptimo
Academy is
Congreso
already
Académico
preparing the
Internacional
7th
que tendrá
International
lugar en
Academic
el año
Congress that
2023
will
en
take
Egipto.
place in
Para
2023
este
in
acto
Egypt.
contaremos
For
con la
this
especial
act, we'll have the
participación
special
de destacadas
participation of
autoridades
prominent
del máximo
authorities of the
nivel de la
highest
Iglesia
level,
de Egipto
the
y de
government
los
of Egypt,
académicos
and of the
miembros
honorary
del directorio de la
academicians
Biblioteca
and
de Alejandría,
members of
Ismail
the
Serekeldin e Islam
Library of Alexandria, Ismail
Quisiera ahora
Sereklin and
dedicar
Hisham
unas
el-Sharif.
palabras a
I
nuestro
would now
nuevo
like to
académico.
dedicate a few words to the new
La
academician.
magnífica
The
disertación
brilliant
del excelentísimo
dissertation
señor doctor
of
Enrique
the
Morera
most
Guajardo
excellent Mr.
y la
Dr. Enrique
brillante
Morera Guajardo
contestación
and the
del
magnificent
excelentísimo señor
response of
doctor
the
Jaume
most
Armengol
excellent
Gurús
Mr. Dr. Jaume
nos
Armengol
ha
Gurús
permitido estar
has allowed
presentes
us to be
en esta
present
celebración
at
de
this
carácter
celebration of a
científico como
scientific
ocurre
nature
en las
as
grandes
it
occasiones.
happens on great
La
occasions.
academia se enriquece
The
con el
Academy is
conocimiento
enriched
y el
by the
compromiso
knowledge
aportados
and the
por el
commitment
excelentísimo
provided
señor
by
doctor
the most
Enrique
excellent
Morera
Mr. Dr.
Guajardo,
Enrique
a
Morera
quien
Guajardo,
acogemos con
whom we
respeto y
welcome with respect
entusiasmo,
and enthusiasm,
sabiendo de él que
hoping
hará
that
honor
he
a su promesa solemne
will
de
honor his
colaboración y
solemn
trabajo
promise of
por la
collaboration
academia.
and work for
Nuestro nuevo
the
académico
Academy.
se suma a la
Our new
atmósfera
academician
característica de
adds to
nuestra
the
propia ciencia
characteristics
y al
atmosphere of our
hacerlo, el
love for
resultado de
science,
la misma
and in
es
doing
netamente
so, the
favorable
result
para
of
la
the sum
academia.
is clearly
Sin duda, su
favorable
incorporación a
to the
nuestra institución
Academy.
es una
Since our
valiosa
recipient in the
aportación,
Doctor of Law,
pues es el ejemplo
professor and
paradigmático
businessman with
de
legal
las
and economic
virtudes,
training, founder and
cualidades
president of
y
the law firm,
perfiles multidimensionales,
he is
las que
undoubtedly
ostentan, que son, en definitiva,
he
las
has many
características que debe tener un
technical and
académico que
legal
forme parte de nuestra corporación.
with various,
La academia ha
with
contado
notarious
una vez más con su asistencia generosa
values for
y
the
nos hemos
Academy.
sentido
And
acompañados en nuestro
once again,
compromiso
the Academy
científico
has had
con la
the
sociedad.
generous assistance, and
Su
we have
apoyo
felt
es
accompanied by our
imprescindible y
scientific
lo agradecemos de
commitment
forma
to
sincera.
society. Your support
Entre
is
todos
essential,
haremos
and we
posible un día
sincerely
el
appreciate it.
acceso
Together, we
universal al
will
conocimiento.
one day make universal
También
access to
quisiera
knowledge
agradecer
possible.
a todas
I
aquellas
would also
personas que
like to
siguen
thank
este
all
acto
those who
de forma
follow this
virtual,
act
ya que la
virtually,
Real Academia Europea
since
de
the Royal
Doctores
European
trabaja
Academy
de
of
forma
Doctors
continuada
works
para que
continuously
todo nuestro
so that
esfuerzo
all
se vea
our
reflejado en
efforts are
todas las
reflected in
actividades,
all the activities,
noticias, trabajos y propuestas
news,
que la
works,
Academia
and
va elaborando.
proposals that the Academy is
Nuestro
preparing.
compromiso es
Our
emprender,
commitment is to
mejorar y transformar
undertake,
para
improve,
inspirar
and
al mundo a
transform,
través
to
de nuestro
inspire the
conocimiento.
world through our
La Real
knowledge.
Academia Europea de
The
Doctores
Royal European
continúa
Academy of Doctors
adelante
continues
con
with
sus
its
proyectos
projects
y
and
actividades con la
activities
esperanza de poder
with the
contar con el
hope of
apoyo
being
de
able to
todos sus
count
miembros
on the support of all its members and walk together towards a new, better future. Thank you very much for your attention.
El acto ha finalizado, se levanta la sesión.
The act is ended, the session is adjourned.